Hey, Mary Ann, just a heads up. I was just kind of curious. I pulled up Judge Martin's docket that's listed on the 34th District Court website,
Yep.
and it's got a whole different set of names listed for today than what we have.
Really? Let me
Yep.
look. Okay, let me pull it up.
Unrelated to the other person who opted in, but
Okay. Let's see. Whoa, you know what I think is happening? Their arraignments, the ones that just popped up. Judge Martin is arraignments, so that's why.
okay. Because I still didn't see any of the other VOPs. I was just like, uh-oh, wait a minute.
Yeah, yeah. They just popped on the docket.
No problem. I just want to give you the heads up in case that wasn't supposed to be there.
Okay, thanks. Sir, who just signed on, who's identified his iPhone, can you hear me?
What? I don't know.
What is your name, please?
Blake Metzger.
Thank you.
What you need to do is see to get a car down. I mean, it's been car.
Hey, Josh, do you need, Mr. Metzger just signed on. Do you need a breakout room with him?
Say that again.
No, I was speaking with your attorney.
Hold on, I can't hear you. There's people talking. Let me move to somewhere that's more quiet.
Hey, Josh, can I talk to you first before you go in a breakout room?
Absolutely.
All right, I'm sorry.
I was speaking to your attorney. Just hold on 1 second, please.
Oh, okay.
So where'd you go?
Nowhere. I thought they were my keys.
Good morning, Mr. Savage. How are you?
Good morning. How are you?
I'm good, thank you. Do you need a breakout room with your client? Are you all set?
Yes. No, I don't need a breakout room. We are ready to go.
Okay, all right, thank you.
You're welcome.
Mr. Metzger, if you can hear me, I'm trying to move you into breakout room number 2. Please click the accept.
This is 1-827-980M, Huron Township versus Michaela Warren. May I have your appearances, please?
Good morning, Your Honor. May it please the court. My name is Matt Savage and I represent Michaela Warren. Michaela, state your name for the record.
Michaela Warren.
Thank you. Mr. Savage, today is the day and time set for hearing in this matter. The memo received from Anthony Grant of this court's probation department indicates that Ms. Warren was placed on a deferred sentence back on September 18, 2018. She was sentenced to 6 months of probation.
Oops.
And the memo dated July 31st indicates that she failed to complete her probation successfully. Thank you. By not completing her alcohol abuse assessment and providing documentation to the probation department, She was set up for a violation hearing in front of Judge Parrott on March the 12th, 2019, and failed to appear in a warrant issued for her arrest after she failed to appear back on March 22nd, 2019. She was arrested and arraigned on July 11th and then released for today's hearing.
That is correct, Your Honor. Judge, we're not asking for a hearing. She understands she has a right to a hearing. She's prepared to waive it and enter a plea of guilty to violating by not completing her probation requirements. So with that being said, if the court would like, I can voir dire her on that, or would the court prefer doing that?
No, sir. Please proceed with your client.
Thank you. Ms. Warren, you heard the court that you had failed to complete your probation conditions within the 6-month period, correct?
Yes,
And the condition that you failed to complete was doing the counseling or the substance abuse assessment and provide that to the court within that 6-month period. Is that true?
that is true.
All right. And you understand you have a right to have a hearing on this matter, and you're prepared to waive that right on record this morning, correct?
Yes,
And what is your plea to not completing your probationary conditions within the 6-month period? Guilty or not guilty? So what would your plea be to not completing?
Oh, guilty.
Okay,
Sorry.
that's all right. Thank you, Judge. I don't have any more questions of Ms. Warren at this time.
Thank you, Mr. Savage. The court will find that your client's plea of guilty to these violations are freely and voluntarily given. The court has accepted that guilty plea. Mr. Grant, what is your recommendation for how we should proceed with Ms. Warren?
I would recommend that she would either re-enter the substance abuse and complete that, or a level 2 alcohol education within 30 days.
Your Honor, if I may briefly, I did fax over this morning a summary of treatment that has been done by Smith's Counseling Centers out of Royal Oak, Michigan. I faxed it to the court's fax number because I did not receive it until this morning from Mr. And that provides a screening, and also I know from talking with Ms. Warren, she actually attended a couple of meetings with Mr. Smith back in 2018, and then went to see him once she was released on this case, and did a session with him there, and he provided a alcohol abuse as a diagnosis and stated that he didn't believe there's any further outpatient treatment needed at this time. Also, if I may, Judge, she did do 10 AA meetings since she was released from jail on this case. I could not print it up and send it, but I do have it in front of me. I can probably email it to the court, but since she's been released, she did AA twice a day until today's date. And if I may also, Judge, in regards to Miss Warren, I have known her since she was 10 years old. My daughter and her played hockey together. Her dad and I coached their team in Belle Tire back at 10U hockey. And all the way for the last 15 years, they've been friends, played hockey up until graduated high school. I still know her. I know her dad very well. Unfortunately, he's on a transplant waiting list right now for having intestines. He suffered from Crohn's disease. Sorry, Judge, it's my my secretary, Tuesday, my dog barking in the background. I apologize. So she's been helping take care of her dad. He's gone through probably, Judge, over 30 surgeries in the last 10 years. She's now attending nursing school at Mercy College in Toledo, in Ohio. She also works 2 jobs, and she has worked 2 jobs since she's been in high school. She's a waitress at California Kitchen. She also works at Firebird, downtown Detroit. Yeah, she's an amazing young lady who's worked real hard to overcome her. She did have issues with alcohol. There's no question back in 2018, but she's doing everything she needs to do. I'm very proud of her. I know her parents are proud of her, and I would ask the court to consider closing her case out today and let her continue on her journey.
Mr. Savage, the court's concern is, A, this warrant was in place for quite a number of years, and B, if you faxed over the alcohol assessment this morning, I don't know, Mr. Grant, have you received that?
No, I don't have anything new, Your Honor. I don't have any of the AA that was discussed or any of the alcohol, the treatment. I do have one form, but it was prior to the amended order that was issued on January 28th, 2019, that requested the substance abuse assessment.
Mr. Savage, what this court is inclined to do is adjourn this matter. Our next date will be August the 21st. Mr. Grant can put his email information in the chat for you. And if you send that information directly to him, both the alcohol assessment and proof of the AA, if Mr. Grant is satisfied with what's provided, when you come back on the 21st, this court will be inclined to close the matter out. If Mr. Grant believes that the information is not sufficient for this court's purposes, we'll have that conversation on that date unless you have some objection.
No, Judge, that sounds like a fair way to resolve this case. I will, if Mr. Grant would provide his email address in the chat, I will get that out to him ASAP, and then I'll wait for Mr. Grant to let me know if we need to appear back on the 21st.
Thank you. And if it is the 21st, Mr. Grant, do you have a time?
Yeah, we could do the 9:30 a.m. on the 21st.
Sounds good. Mr. Savage, Mr. Grant will type that email address in for you.
Thank you so much. Thank you, Mr. Grant.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. I'll see you on the 21st, unless you hear something differently from Mr. Grant, okay?
Yes.
Thank you.
Thank you.
Have a good day. Good luck to you, Ms. Warren.
Thank you.
This is 220381. This is State of Michigan versus Blake Metzger. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of defendant probationer, Mr. Blake Metzger. Mr. Metzger, state your name for the record, please.
Blake Metzger.
Thank you, Mr. Hadley and Mr. Metzger. Today is the day and time set for the adjourned hearing in this matter. Mr. Metzger was to provide proof of his therapy and to resume payments in this matter. Mr. Hadley, how are we proceeding this morning?
Your Honor, we come bearing good news as it relates to the therapy notes. Mr. Metzger, and we do apologize to Ms. Rapp for getting them over so late, but we were able to provide her with documentation of the therapy. It's my understanding after speaking with Ms. Rapp, that leaves us the outstanding issue of the $850 balance to be paid. And again, I don't want to step over into Ms. Rapp's lane, but I think what we would both be asking for at this time is for Mr. Metzger to be discharged from probation, to have the matter turned over to collections, as the only matter remaining is the balance owed.
Ms. Rapp, is that an accurate summary of the status of Mr. Metzger's matter?
That's correct, Your Honor.
Mr. Metzger will be discharged. The file will be turned over to Collections Department for payment on the remaining fines and costs. Mr. Hadley, is there anything else in this matter?
No, there isn't, Your Honor. Thank you very much, Mr. Metzger. Good luck to you.
Thank you.
Thank you, Mr. Metzger. Have a good day.
You do the same.
Thank you. Mr. Savage, was there something else, sir?
Sorry, no, Your Honor. I was trying to just get the email address written down. I couldn't find a pen.
Oh, no, that's okay. I saw you hanging around. I didn't see your name next to any other file. Thank you,
No,
sir.
It was a pleasure. Thank you, Judge. Bye now.
Bye-bye. Good morning, Pravachi.
Morning, Your Honor. How are you today?
I am wonderful. How are you?
Very good. I got one for you today. I got Colin, C-O-L-O-N. He's in for a Tether violation.
How you doing, Your Honor?
Good morning. Your name, I'm sorry.
Jalen Cologne.
I don't see that. Jaylen? Sir? Sir, spell your first and last name for me.
Jaylen. Cologne, Colon.
I want the clerks look it up because I don't see that name or a file with that name on it.
Your Honor, I think it was assigned to Judge Oakley. It's a tether violation. Let's see.
I still would expect to see the file at least, so.
Judge, I just looked it up and it, Marlisa, it's on your docket for arraignment. I will get a hold of her and see what the file is.
Thank you. Sir, if you sit tight, we'll have somebody track down the file. As soon as it gets up here, we'll get you connected with one of the court-appointed attorneys, if that's how you like to proceed this morning, okay?
Thank you.
Thank you. This is 220705SM. This is State of Michigan versus Gabriel Stevens. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. Gabriel Stevens. Mr. Stevens, state your name for the court.
Gabriel Stevens.
Good morning, Mr. Stevens. Today is the day and time set for hearing on the probation violation. This court has received a report from Anthony Grant of the court's probation department indicating that Mr. Stevens failed to provide updated documentation for his 12-week anger management class or his parenting class. He's failed to maintain his payment plan with the court, having made the last payment on March 21st, 2023. Mr. Hadley, how are we proceeding this morning in this matter?
Your Honor, as to the violation of probation, I've spoken to my client. We plead guilty to these technical violations. He admits that he's not completed the anger management class, the parenting classes, but we'd like to offer in the way of a brief explanation or maybe some context. Mr. Stevens has stated to me that he did pay the fees associated with getting the parenting classes done. He's just working through the scheduling of such. Moving to the fines that are owed, Your Honor, Mr. Stevens has indicated to me that he's been out of work for the past few months. He does have a job interview tomorrow. So we're optimistic that he's going to have a better financial situation in the near future on the horizon. So I guess what we would defer to Mr. Grant at this time, but we would ask for a little more time for Mr. Stevens to at least get these classes that he's already paid for completed.
Mr. Grant.
I made contact with what Mr. Stevens did is he registered for both classes and never attended one session of either class. I made contact with Pam's place and confirmed that. So for an individual that's been out of work for a couple of months and has time on his hand and the class has been paid for, I'm not sure why he hasn't attended any of those classes. If this is something that he's going to attend, I guess we're okay with that. And if we want to set a review for March 21st, or not March, I'm sorry, August 21st, we could look at it again, Your Honor.
Mr. Hadley?
Mr. Stevens, did you understand everything with that? We have no issue with that. We would thank Mr. Grant for extending us the extra time to get this concluded. Mr. Stevens, do you understand what Mr. Grant and the court are saying, that you got to get these classes scheduled, especially since you're not working right now?
Yeah, but yeah, I paid for them, but it's like they didn't send me the information like about it. They didn't send me like I was trying to get the Zoom classes, and they didn't go email or the Zoom calls.
Mr. Stevens, here's this court's opinion. You've been placed on probation for 8 months now. So you've had 8 months to complete a 12-week course and you haven't done that. And if it's that you've paid for it and you're waiting for someone else to give you information about scheduling, then that's, and as Mr. Grant indicated, you're not working. You've had time and opportunity to follow up on those things. The court does not take kindly to people who don't undertake minimal efforts to do what is necessary of them to be successful on probation. And when this court imposes a sentence, it's always the same conversation. We want you to be successful. If you need something, reach out to the probation department. When you're struggling a little bit, don't wait until there's a violation notice, because that means it's too late. Mr. Grant is here every day. Ms. Rapp is here. There are people available to help you. So what we'll do is we'll adjourn this matter over to August the 21st, 2023 at, Mr. Grant, are we back at 9:30?
Yes, Your Honor.
We're back at 9:30, and Mr. Stevens, in the interim, you should undertake some efforts to follow up with whomever it is that you need to follow up with to get these classes scheduled.
Okay.
And if you, as Mr. Hadley indicated, you have a job interview, fingers crossed that you are hired and able to start working, start making payments on the fines and costs. But the court has accepted your plea of guilty to this technical violation of your probation. We'll resume conversation in this matter on August the 21st at 9:30 a.m. Is there anything else, Mr. Hadley?
No, we thank Mr. Rapp and the court's understanding, and Mr. Stevens, we'll see you in August 31st.
Okay.
Have a good day and good luck to you, Mr. Stevens.
Okay.
This is 230570 SM. This is State of Michigan versus Dennis Thick. May I have your appearances, please?
Your Honor, respectfully, 186 MIDC Arraignment Counsel appearing on behalf of Mr. Thick. Mr. Thick, please say your name.
Dennis Austin Thick.
Thank you, sir. You've had the opportunity to speak to Mr. Jadala this morning. You understand why we're here?
Yes, ma'am.
Thank you. For purposes of arraignment, Mr. Jadala, how are we proceeding?
For purposes of arraignment, we'd waive formal reading and stand mute and just respect the request to allocute on my client's behalf.
Thank you. Mr. Thick, were you able to hear Mr. Jadala just now?
A little bit, vaguely.
Sir, what he's done is waive your right to hear the formal reading of the complaint against you and has you stand mute to those charges. You have a right to be considered for pretrial release, sir. There is a recommendation from Van Buren Township that your bond be set at 10,000, 10%. And that condition of your bond is that you have no contact with the Atchison family. That includes Craig, Medina, Ava, and Ella, and that you do not return to Atchison Ford at 9800 Belleville Road or 48932 Peninsula Drive in Van Buren Township, that you have no contact with Atchison Ford employees, and that if you post this bond, that you be placed on GPS tether for location purposes. Mr. Jadala, your comment as to bond.
Your Honor, Mr. Thick is 53 years old, Your Honor. He does have 4 stepchildren, 3 biological children, 3 of them being minors still, Your Honor. He's currently unemployed. He's not on probation or parole. He has no holds or warrants, Your Honor. He's been incarcerated now for the last 4 days since the date of the offense, the 28th. Your Honor, I don't believe he has any capious history or any reason to be a threat or fear. He understands the no contact order. He understands the do not return order. We respect the request that you consider a personal bond.
Mr. Thick, Mr. Jadala has indicated that you're unemployed. How do you support yourself, sir?
Pardon me, my wife's got a job, you know. My kid's mother, she pays for it. I get a little Social Security, but that's for it the most part. VA gives me a couple bucks too, like 10% or something.
Thank you, Mr. Thick. Mr. Jadala, the court does note in the file, there is a criminal history, but it's more, the most recent thing showing is more than 20 years old. For that reason, Mr. Thick, the court will deviate in part from the recommendation, set your bond at 10,000 personal. You don't need to post any money, sir, but the conditions will be that you be placed on GPS tether for location purposes, and that you have no contact with the victims, the Atchison family, including the four named previously, and that you do not return to Atchison Ford and do not return to the home on Peninsula Drive. And just so we're clear, Mr. Thick, no contact means no contact, no direct contact, no contact with third persons, no contact through social media, sir. If the court receives report from Van Buren Township Department of Public Safety that you've made efforts to be in contact or communication with any of the persons previously named and identified, that could be viewed as a violation of the terms of your pretrial release. Your bond could be revoked and you can spend the rest of these proceedings in custody. Do you understand?
Yes, I do, ma'am.
Thank you. Sir, your next appearance date will be a pretrial in person on August the 9th at 9:45 a.m. Again, this case number is 230570 SM. Next appearance date is a pretrial on August 9th in person at 9:45 in courtroom number 2 with Judge Brian Oakley. Mr. Jadala, anything else in this matter?
Nothing further, Judge.
Anything else, Van Buren?
No, Your Honor, thank you.
Thank you. Mr. Thick, good luck to you, sir.
Thank you, ma'am.
And Your Honor, I'm going to need to return to the breakout room. They need to grab the other two defendants from, I believe it's Belleville.
Thank you. Mr. Hadley, the last thing on your docket, I do believe, is 220113 SM. This is State of Michigan versus Alan Thompson. This matter was adjourned from June the 26th to allow Mr. Thompson time to correct the previously indicated oversights, that being treatment or education at veterans counseling, making payments on the balance due in this matter. And it began testing for drugs and alcohol at on site. Mr. Thompson was present on June the 26th when the court set this adjourned date. Case was scheduled at 9:30 today. It's now 9:59 by this court's clock, defendant having failed to appear. Mr. Grant.
Your Honor, I did try even calling Mr. Thompson this morning and sent him an email. I've received no updated documentation on any of the things that we were just discussed. So at this point, I would recommend we turn it over to warrant status.
Thank you. Mr. Hadley, based on Mr. Thompson's failure to appear this morning, the court will issue bench warrant in this matter, 5,010%. Anything else, Mr. Hadley?
No, Your Honor, I think that covers it for today. Thank you, Ms. Rapp. Mr. Grant?
Thank you.
Thank you,
Have a
Mr.
great day,
Graham.
Your Honor. Can I be of any assistance for anything else today, Your Honor, before I log out?
I don't think so. I think Mr. Judala is here for our arraignment docket.
And he's good. He's got him covered, I'm sure. So everyone, have a great day.
Thank you. Marianne, if she's able to get a hold of Mr. Colin's attorney and a prosecutor, I don't know. I haven't seen the file yet, so I don't know what the allegation is for the violation.
Judge, if you'd like to call me at my desk. It's Marlisa.
You want me to call you?
Please.
Hey. Oh. Really? Who's this attorney? It's wait, I'm sorry. This is arraignment on a new charge or violation. That's what, okay. Okay. Has she gotten a hold of somebody from Crip's office? I'm okay with whatever is the best use of resources right now in terms of getting the prosecutor on and getting the file together and everything else. But I see him sitting here and okay. No, I'm fine. I mean, whatever works for you all. Somebody did, which I find very interesting. I have questions. Do you have any idea? Oh. Oh. Okay. We're here, so when you figure out how you want, what's best way to proceed, just let us know. Thank you. All right. Mr. Jadala, did you speak to both Mr. Norris and Ms. Chestnut?
I did, Judge.
Thank you. These are 22BL005230M, 22BL00965A, and I'm sorry, B and C. These are all City of Belleville versus Sean Norris. May I have your appearance, please?
Your Honor, respectfully, 62186, MIDC Arraignment Counsel, on behalf of Mr. Norris. Your Honor, for purposes of today's formal reading and staying mute, Mr. Norris understands what he's being charged with as well as the possible penalties. I've gone over his rights. He does understand those, Judge.
Thank you. State your name for me, please, sir.
Sean Norris.
Mr. Norris, you were able to speak to Mr. Jadala this morning. You understand the reason why we're here?
Yes.
Thank you. In the 523 file, Mr. Norris had previously been arraigned back on September 15, 2022, and it failed to appear for a pretrial conference in this courtroom back on November 17, 2022. Mr. Jadala, there is a request for a bond of 10,000, 10% with GPS tether and no narcotics use in this file. Your comment as to bond in this disorderly person file.
Your Honor, my client is 41 years old. He lets me know he is gainfully employed at Get the Scoop, Your Honor. He manages the ice cream shop, Your Honor. He lets me know he's not on probation or parole. He's been in custody 2 days, and he does acknowledge the warrants that he has out of Wixom, Oakland County, Allen Park, Lincoln Park, and Novi. Those are all traffic matters, Your Honor. We just respectfully request that this give a reasonable bond in this matter.
Thank you. In the disorderly person file, the court will set the bond at 5,000, 10%. The next appearance date in this matter will be, I saw the sticker, on August 10th, 2023 at 10:10 a.m. That's on Zoom. Back with me, Judge Martin in courtroom number 1, Mr. Norris. And then in the B and C files, Mr. Norris had not previously been arraigned.
Your Honor, we'd also wait for a reading and stand mute on those matters, Your Honor.
Thank you, Mr. Jadala. The B file is a driving while license suspended. The court will set bond at 5,000. Personal. That return date, sir, will be that August 10th, 2023 pretrial at 10:10 a.m. Back with me, Judge Martin in courtroom number 1 on Zoom. The C file is an driving while intoxicated. Bond is 5,000 personal. No alcohol or non-prescription drugs. Return date of August 10th, 2023 at 10:10 a.m. on Zoom. Is there anything else for Mr. Oh, sorry, Mr. Norris? The other thing is that you have outstanding matters with this court where you owe a total of $1,047 before you appear on August 10th. Please be in contact with this court's collection department. You can go on the court's website. There's a drop-down box to submit a request for a payment plan. You can call the court's collection department, set a payment plan, or you can appear in person. Anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Thank you. Mr. Norris, good luck to you. I'll see you on August 10th, sir.
Thank you.
These are 23BL00351 A and B. These are City of Belleville versus Laura Chestnut. May I have your appearance, please?
Your Honor, respectfully, Sam Jadala, P62186, and my deceased arraignment counsel appearing on behalf of Ms. Chestnut. Purposes of arraignment would waive formal reading and stand mute. Ms. Chestnut understands what she's being charged with as well as the possible penalties. I've gone over her rights. She does understand those, Judge.
Thank you. Ms. Chestnut, state your name for me, please.
Laura Chestnut.
Thank you. You had the opportunity to speak to Mr. Jadala this morning. You understand why we're here?
Yes, ma'am.
Mr. Jadala has waived your right to have the charges against you read and has you stand mute to those charges. There is a bond recommendation in the file from the Belleville Police Department where they indicate that they do not oppose personal bond in this matter, although you have outstanding warrants for misdemeanor and traffic matters. That being the case, the court will set bond in this matter at $5,000 personal. Ms. Chestnut, you do not need to post any money, but what you must do is continue to appear as directed by this court until the matter is resolved in its entirety. Your next appearance date will be a pretrial conference on August 10th, 2023 at 10 a.m. That's back here with me, Judge Martin, in courtroom number 1. The matter will be on Zoom. Mr. Jadala, anything else on behalf of Ms. Chestnut?
Nothing further, Judge. Thank you.
Thank you, Ms. Chestnut. I will see you on August 10th, ma'am, on Zoom at 10 a.m. Have a good day and good luck to you.
Thank you.
Thank you, Your Honor. Have a good
You're
day.
welcome. Thank you.
Your Honor, I will return if I'm notified of any further in custody, Judge.
Thank you for your help, Mr. Jadala.
Absolutely.
Judge,
Ma'am.
Mr. Cripps has made contact with us via email. He will be logging in. And then I've emailed the prosecutor also. They wanted to be on also.
I saw your message and I just wanted to inquire what shortly is, or did you receive any indication?
I received my message from somebody else, so he was going to be logging
Okay.
in a few minutes.
In a few minutes?
Well, that was
I'm
when I
just
got the
asking
email.
because I'm gonna walk downstairs and hand you your files. And then I'll come right back upstairs.
Okay,
Thank you.
thank you.
Good morning, Mr. Cripps. Sir, do you need a breakout room with your client? Can you hear me? You're muted.
Sorry, been in trial for 2 weeks, so I just taking a break from the trial.
Okay. Do you need a breakout room with your client?
Yes.
Okay.
Mr. DeGrazia, as soon as Mr. Cripps or someone from his office gets here, we'll get this matter called.
Judge, he
Or
is
is he here?
Yep. he's
Thank
here.
you. Mr. Cripps is here?
Yes, he's in speaking with his client right now.
Oh, he's not oh, he must have been. I didn't see him on Zoom.
He was here, and I don't know what happened. They were in a breakout room. Maybe he just had to log out real quick.
Oh, he's back. This is 220571 FY State of Michigan versus Jalen Collin. May I have your appearances, please?
Dominic DeGrazia, P 69815 on behalf of the people.
And good morning, Your Honor. David Cripps, P 34972, appearing on behalf of Jalen Cologne. No objection to Zoom, of course.
Mr. Cologne, state your name for the record.
Jalen Cologne.
Thank you. Today is the day and time set for hearing on a tether violation. Mr. Cripps, you've had the opportunity to speak to your client.
Yes, I have, Your Honor. Thank you.
How are we proceeding this morning?
Well, Judge, it appears as if there's not a tether violation technically itself. It was in compliance with all the curfew regulations.
And Judge, I think from our perspective, we'd be arguing to increase the defendant's bond based on new criminal activity.
This is not a bond hearing, Your Honor. This is a tether violation hearing to see whether he violated his tether. Now, I know he got arrested over the weekend, but I think it's just a case that's under investigation right now without any warrants having been signed yet, unless I don't understand the situation.
Well, I would say that being arrested and engaging in criminal activity is in and of itself a violation of his bond.
I suggest otherwise. Not every single person in our society who's arrested is automatically guilty of something, especially when a warrant hasn't even been assigned yet. That's what I was told over the weekend. Is it just a pending investigation? If it's something different than that, I need to know.
Mr. Cripps and Mr. DeGrazia, this court just reviewed the report within the last 10 minutes, and the face of it indicates that he was not in violation of the curfew at this time of his arrest, but there are some allegations of potentially criminal activity, Mr. Cripps, if I'm reading the report correctly. And the condition of his bond at 4D is that he not commit any crime while released.
That's
so
correct.
If your interpretation is different than mine?
No, but my interpretation of what committing a crime is, which is the fact that it's an arrest, Judge. He hasn't been charged, as far as I know, he hasn't been charged with anything. And in fact, as far as I know, there hasn't even been a warrant signed by any prosecuting authority. If I'm wrong about that, I'll be corrected, but that's what I checked over the weekend. I couldn't find any warrants.
And Judge, I did email a member of your staff, and I CC'd Mr. Cripps on it. The defendant purchased the firearm while on bond, and he attempted to purchase 2 more. And on the documents, there's a clear indication that if somebody is under an indictment or an information for a pending felony, you are prohibited from purchasing a firearm. And the defendant, according to these documents at least, checked the box for no, which is in and of itself a crime. Now, I can't, tell the federal prosecutors what to do, but on certainly a question of his bond and whether he's violated his bond, I think there is enough information for the court to make a determination if he's violated his bond.
I didn't hear what Mr. DeGrazia said. My Zoom went out, but as I understand it, there's no charges that have been filed against him. And this is a tether violation allegation, not a bond violation.
The tether is a condition of his bond. Trying to split the baby here makes no sense to me.
Well, but am I wrong about this? But it is my understanding no charges have been brought against my client. It's just a pending investigation. Did you say by the federal authorities? Is that what you said?
Well, yes, I can't speak for the federal authorities, but I know that it's written right on the document that your client signed that it is a federal crime to lie on those documents.
Well, I think we can leave that for them to decide. But again, he hasn't been indicted on anything. There's no signed complaints against him that I'm aware of in state court. So it's just a pending investigation. So looking at the presumption of innocence, Your Honor, and there's been no tether violation. It says that he's in compliance with this curfew.
Anything else, Mr. DeGrazia?
No, Judge, I would just ask that the defendant's bond be set at remand.
And I would ask that the bond be continued, Your Honor. If there's a bond hearing that the prosecution wants to file, then they can feel free to do that. But this is just a tether violation hearing where no actual charges have been brought.
Mr. DeGrazia, I believe Mr. Cripps' argument is accurate. The face of the incident report specifically provides that Mr. Colon was not in violation of his tether if there is a subsequent hearing for violation of his bond or because of these, some new charges arise out of the incident that happened over the weekend, I think that's a horse of a different color, but for right now, it's a tether violation unless you see something that I don't see in the incident report.
Well, Judge, what I can say is, you know, it indicates right on the tether violation report that he was explained to, agreed to, and signed for all the rules and regulations of the Wayne County Sheriff's tether program. Part of that tether program is that he not be arrested, not have any criminal conduct. So Mr. Cripps is hanging his argument on the fact that he hasn't formally been charged yet, but merely the act of being arrested is in and of itself is a violation of the tether program, regardless of whether the author of the tether report, you know, puts that in his report.
Mr. DeGrazia, is there something attached to the incident report that says that that is a violation of the tether program?
No, Judge, I don't, what was emailed to me is simply one page. I mean, I'd be happy to get you the details of the tether report, but the sheriff's office didn't share the report with me prior to this hearing, so.
Mr. Cripps, while the court does, again, appreciate the argument you make and believe there is, the court does have some concern regarding Mr. Cologne's activity, and while will not do remand, will increase his bond. $200,000, 10%. Leave the GPS tether in place. This matter is not scheduled again until September 28th at 1 p.m. with Judge Oakley. Anything else, Mr. DeGrazia?
No, Judge.
Anything else, Mr. Cripps?
No, Your Honor, thank you very much.
Thank you. Have a good day.
Thank you, everyone.
Thank you, Pravanchi. Marlisa, is there anything else?
Not at this time.
Thank you.
Thank you.